Speaker.
Thank you, Mr Simpson. I call the Honourable Leanne Dalzell.
Thank you, Mr Speaker. Mr Speaker, I believe that this legislation represents a very serious retrograde step in the history of the Family Court. I remember when the Family Court legislation was passed back in, I think it was 1980. I haven't got the thing in front of me, but I was completing my law degree at the time. And so there was a lot of interest in the Family Court. Yes, I know, I was just a child. I was... the point was that the Family Court course was changing because the law was changing, and that was the point that I wanted to make. So it certainly was designed, as we said in our minority report, with a jurisdiction covering care of children, domestic violence and property matters, with a high degree of state assistance provided to the parties, signalling an important policy principle: the state has an interest in effective and just resolution of family disputes. And that's what the law was based on, Mr Speaker. Apart from the money-saving driver that really is behind this bill, the ideology that lies underneath it is that family disputes are private matters. Two adults whose marriage, civil union or relationship is unravelling cannot expect to call on the state for any support in resolving the disputes that necessarily arise in such case, and potentially the conflict that arises. And of course, we all know that conflict can be healthy. How one manages conflict is really the primary consideration. But the Minister made it very clear in her comments that it was really up to private individuals to deal with their private disputes. That was not an issue for the state. And the chair of the Select Committee, who I will say that has chaired the process extremely well, but we do disagree on this matter, that it isn't a matter for purely for private consideration. And I don't think that the divide is as he stated it to be. He said that the government has a view that it's private and the government should stay out of it, and that therefore the opposite is that Labor believes that we have an interest in the private context. No, we don't. It's the peaceful resolution of the dispute. It's the conflict resolution that is very much in the public interest. That is the public good, and that has been what the counselling services that were made available, 6 sessions per couple for free, so funded entirely by the state. That's what those 6 sessions were for. Mr Speaker, I think that public good could actually be framed by reference to the legislation from the Act at the time, which was the focus of everyone on reconciliation and conciliation. And that really does put a line underneath what is the most fundamental aspect of the Family Court legislation as it was established more than 30 years ago. But it was also very much focused on ensuring that the best interests of the parties were able to be served in dealing with what was a difficult situation. Now, when we go to the regulatory impact statement, we find why the government wants to get rid of the 6 free counselling sessions, and as my colleague has already said, that was reduced to 3. It's down to 1, I think, in October, which really we discover in the regulatory impact statement why we're getting rid of the counselling sessions. It's not because we don't like people sorting out their own disputes. It's because it's costing $9.7 million. $9.7 million. So that's the reason for getting rid of the counselling provisions. Nowhere in the regulatory impact statement can I find what the absence of free counselling sessions will cost in the medium term or the long term. Reduced relationship breakdowns. We've been told that there were a number of couples that reconciled as a result of the free counselling, and of course there are flow-on effects to children with relationship breakdown and how that's managed. Agreed day-to-day care arrangements, more understanding about the relationship, more ability to cope, less disputes between separating parents. The list goes on, and I could go on to the intergenerational intergenerational impact, because we know that relationship breakdown has an ongoing effect with children. We know that domestic violence is intergenerational. So all of these issues are matters that should be the subject of the regulatory impact statement, but it's very short-sighted. It's only interested in how much cost is going into counselling at the moment. Mr. Speaker, it doesn't seem that the government is really interested in the long-term costs. It's really about individual ministers interested in reducing their budgets in the here and now, and it doesn't really matter that a future government will have to pay the price in another minister's budget down the track. Mr. Speaker, the process for changing this law was excellent. It was the best process that you could possibly imagine. Members might have heard me commenting on a previous bill about how important it is to get people around the table and to look at the evidence and to actually bring the experts to the table. I know evidence-based approach is not popular with the government, but I do think that it's got something to offer us as a nation. So what happened was that the government introduced released a discussion document, and they got together, so the minister got together with the profession, the academics, the officials, the NGOs, everyone who was anyone in the whole area came to the table, or actually came to Parliament, to the Legislative Council chamber, where they held an in-depth conference, where they workshopped the issues, where they traversed the issues, where there was good, healthy debate and understanding. And out of that, there was an expert reference group established. So what could possibly go wrong? What could possibly go wrong when such a good process was established? Well, I think the requirement to cut money out of the justice budget is what went wrong, and so an online survey was given more weight than the expert advice, and that is unfortunate, to say the least. So what we ended up with legislation that pretended that early legal advice doesn't make a difference to people's behaviour. We had lawyers, but not just lawyers. We also had some of their clients, previous litigants, who came to us, and they said that they understood that their rights were quite different until they had received advice from their lawyer. There were a lot of men who felt that the family court was biased against men, against male litigants. They felt there were a lot of women who assumed that they were automatically entitled to have day-to-day care of their child. There were a number of misconceptions that were remedied in that first consultation with the lawyer. And then we heard what happened second, which was, so they had the initial conversation with the lawyer, and then the lawyer would refer them off for counselling. As I say, reconciliation and conciliation. The number of lawyers who told us that they saw people for that initial advice, they sent them off for counselling, and they never saw 95% of them ever again. And that's because the counselling service works. It might cost $9.7 million, but it's incredibly effective. So why would we remove the one thing that's known to be effective and replace it with something that we don't know the detail of, the family dispute resolution, and actually will make people pay for that, and will actually indicate that that could be as much as $900 for X number of sessions, because we don't even know what the number of sessions that will pay for either. This is nuts. Why would you throw out what works and replace it with the unknown, unless all you cared about was saving the money up front instead of thinking of the long-term consequences? Mr. Speaker, the ones that came back had a range of problems that were highly complex. So instead of that, so basically the government wants to see those cases only going to the court and everything else dealt with in family dispute resolution before they can come near the court. And I think that the trouble with that is that it ignores the dynamics of a relationship in meltdown. Completely ignores it, especially where one has already made the decision to move on and maybe entered into another relationship. And we heard that from submitter after submitter after submitter. It depends. It depends where you're at. If your husband comes home and says, I'm leaving you for the person I had an affair with for the last 15 years, or the other way round, the woman comes home and says, by the way, I'm leaving you for the person I've been having an affair with. Look, the bottom line is that these are enormously emotional, difficult issues for people to face up to. They actually need support, and power imbalances can be extremely well hidden when people don't know who is on their side. At least when they have a lawyer sitting with them, they know that they've got somebody who's on their side, who they can tell everything to, and we can get good results. Mr. Speaker, I think this bill has a lot of problems within it, and that is why the Labour Party will not be supporting it.
I call the honourable member Materia to